Hi, everybody. Good evening. Our speaker tonight is Bonnie Burkhardt, and I'm going to read a little introduction on her. She's a software engineer and president of her company, Blue Ridge Software Consulting. She has a top security clearance and over 35 years of experience intercepting and analyzing signals for the Department of Defense. In addition to writing software, she has worked as a network protocol engineer, system administrator, and intelligence analyst. Because of her job duties, she has had over 100 classes of interception and privacy laws taught by the DoD. Ms. Burkhardt has used her knowledge of these laws to expand her business into providing expert witness support to attorneys. With 2 cases, she wrote amicus briefs as a pro se litigant and submitted the briefs to the appellate court. These briefs form the basis of her book, Manufacturing Criminals, which I'm holding right now, Fourth Amendment Decay and the Electric Age. She presented a seminar at the National Association of Criminal Defense Lawyers Conference in Las Vegas this past April. Ms. Burkhardt was born and raised in North Dakota and drove her dad's combine during harvest season. I love that. She has a BS in applied math and MS in computer science and engineering. She and her husband, Walter, moved to Virginia in 1989. They have grown children who were born and raised in Virginia. After becoming an empty nester, she became active in politics and advocating for Fourth Amendment rights. Thank you so much, Bonnie. Welcome.
You're welcome. Well, thank you for having me. All right, well, let me just get started. As you know, my name is Bonnie Burkhardt. So that's my contact information up on your screen with my email address. This is my book. It's got 500 references to law, case law, and it was somewhat written for attorneys. So there's all the footnotes have the references that they might need for writing briefs. Caveat, next. This is an engineering analysis of law. I'm not an attorney, so I'm not providing legal advice. So please consult an attorney. I don't do legal advice. I just teach attorneys about law. So next, this is the overview of what I'm going to talk about. I'm going to talk about the Fourth Amendment and the related laws and a little bit of its history. Then I'm going to talk about the online investigations. There's 2 major categories, online solicitation of a minor and then possession of child pornography. And in the middle, I have both of them. If what they do is they unmask the identities of the users if they don't know who they are. And that also has some violations of privacy law. There's some other violations too that I'm going to touch on. Next. Fourth Amendment. This is a constraint on the government. The rights of the people to be secure in their persons, houses, and papers, including electronic papers, and effects against unreasonable search and seizures shall not be violated unless a warrant is issued based on probable cause. This is the whole basis of what I'm going to talk about tonight. Interception law. I put the little yellow rectangle up in the top there. So those are page numbers in my book. So if you want to look at for more information, these are little references, but I won't mention them anymore. I just want to highlight them. The interception laws in the days of Watergate. I mean, some of us remember Watergate, but the Watergate scandal, they planted a tape recorder in the hotel room of the Democrat headquarters at the Watergate Hotel. But they didn't tap a wire. So there were no wiretap laws violated. So they wanted to charge them with wiretapping, but they couldn't because it wasn't against the law to plant a tape recorder. So they only got charged with trespassing. This kind of opened everyone's eyes that the interception laws were not sufficient. And it was the dawn of the electronic age with the internet and all these networking things for cell phones, all that was coming of age. They could see them on the horizon, so they needed to update the law. So the first update happened in 1981. Ronald Reagan signed the Executive Order 12333. This is still taught today. The definition of electronic surveillance, which is the basis for the law of the modern law, is acquisition of private communications using electronic means without the consent of a person who is a party to an electronic communication, or without the consent who's visibly present at the place of communications for like oral communications. Okay, so meaning of person, I've highlighted several things and you'll see them. That's what I'm going to talk about and emphasize throughout this. You're going to see this referenced several times. So I'm going to refer back to this. Then in 1986, the Electronic Communications Privacy Act was passed, which modernized the laws. It has 3 sections to it: the interception law, the pen register law, and the stored communication law. Interception law has to do with wire, electronic, and oral communications like tape recorders in hotel rooms. Pen register laws has to do with like the envelope, the dialing, routing, and addressing, and the stored communication has to do with like store and forward type of communications, and also the transactional records that the businesses keep about who you called and who you sent emails to. States then created their own versions of these laws, defining them as felonies or misdemeanors. Virginia's was passed in 1987, so your state was probably very similar. This is a category of what is protected by each one. The interception law is the most strict, and it provides the highest level of protection. It protects oral communications in person, phone calls, text messages, emails, content, any attachments to an email, and also hash codes. I'm going to talk about hash codes. When you deal with child pornography, it all keys off of hash codes. The pen register law, that's kind of like the envelope. You know, who's it addressed to? What mail truck did it go into? What route did it pass on? Who's the return addressee? That's the envelope, not versus the content, like what's inside the envelope. So email addresses, IP addresses, phone numbers, routing information, and ownership. The stored communication law is large files in transit, like stored and forward or backup services, transactional records, and also hash codes come into play in stored communication law also. ICAC, we have to talk about the elephant in the room. ICAC, Internet Crimes Against Children Task Force, was founded in 1998. Little bitty county suddenly becomes the headquarters of all this high-tech stuff. They conduct investigations for soliciting a minor, and also then they added child pornography. They have sworn under oath. They have no training on the laws I just talked about, electronic communications privacy laws, no training. And ignorance of the law is no excuse, especially for law enforcement. So we're going to talk about is all the laws are violating tonight. First, solicitation of a minor. I'm going to go over some examples, and then I'm going to take these 3 examples and show you how the laws are being violated in each case. Parents report a suspicious text being sent to their teen. All right, every parent has concerns about this. So this is proper procedure, you know, to report it, and the officers take a look at it. But then the officer takes control of the teen's phone and impersonates the teen and sends messages as if he is the teen. Okay. Second type of impersonation is using a young looking officer who's maybe a cadet, maybe a secretary, something like that, but they post a picture of this young looking hottie who is an adult, and then some 40-year-old bald-headed 250-pound guy impersonates them. The third kind is what they call a geomorph, which is a picture of that they edited together, so it's not really a real person. They use the eyes of one person, the nose of somebody else, and they kind of mush them together and get something that looks like a human, but technically it's not a real picture, and that's called a geomorph. So that is a thing. Okay, now I'm going to talk about the law with all these 3 variations. Impersonation of a teen. Let's talk about this case a bit. The parents reported there's no criminal activity committed by the adult yet. The officer got written permission. I'm going to talk about written permission, how it's useless, from the parents to use the teen's phone and portray the teen while communicating with the suspect. And they use the teen's phone so the caller ID would match. So it's a means of identification. And then they used entrapment. I'm not going to tackle entrapment. You talk to the officers about, or your attorneys about entrapment. I'm just going to deal with ECPA law primarily here, but they use entrapment to cause the crime to be committed. Next scenario, This is Alex VA. This is the actual cell phone capture put in discovery. Notice there's no age on the photo. It's on Grindr. It just says Alex VA, and it's good looking young gentleman. But there's 3 people that pooled their personal, whatever you want to call it. You had one officer, which is the 45-year-old bald-headed guy, texting and pretending to be the guy in the photo. You had the guy in the photo who did nothing other than pose for the picture. Okay, so he was not part of any communication. And then you have a third officer who, you know, could sound young on a phone. So they have 3 people portraying one character, and that's 3 birth certificates, not one. And there's no indication of age. I said that, and they claim to be 14 years old. All right. Next scenario is Lily. Lily supposedly doesn't exist. However, I located her at a meeting. So I'll get to that in a second. Lily is supposedly a geomorph where they edited it. They did edit this photo. They removed the braces off her teeth, but you know, the fact that it's a geomorph, I will challenge that, but you know, that's for another discussion. And the 45-year-old bald-headed guy impersonated her and claimed to be a 14-year-old girl. Since she is a geomorph, she has no birth certificate. So, and since she's imaginary, she can't be present and she can't grant consent to recorded conversations, okay? All right, now let's talk about the law. What is the meaning of a person? You wouldn't have to think that we would have to start with something so basic. A person is a single human being, human, child, or individual that is born alive and at some stage of the development. An imaginary person like Lily is not a person or a human. It is a thing. Okay, and ICAC likes to call these investigative personas. They are not. They are things. And a wiretap device is a thing. You can't use a thing to intercept communications unless you have a warrant. I'm going to bring you back to the definition of electronic surveillance. Okay, it means acquiring private communications by a person, or the person is visibly present. All right, this is electronic surveillance. Now, do you see a problem with these 3 scenarios with a person and being visibly present? Meaning of impersonate is an act of impersonating someone else. A persona is actually a human being who is projecting an impression, you know, like if I decided to wear a wig and pigtails, or, you know, I'm Elga, you know, it's talking in a fake accent, you know, I'm from Norway. That is a persona. Posting a picture of somebody else and impersonating them is not a persona, but they use the words, I believe, to deceive the courts and snooker the judges. Executive orders. Here we go back to tie these 2 together. Impersonators and imaginary people cannot be lawful parties to communication because they can't be visibly present. Imaginary people can't be visibly present anywhere to have a similar in-person conversation. And if you're impersonating them, I mean, if you had a 45-year-old bald-headed guy show up, that would be pretty obvious they're not Lily. Okay. Now, if he did come in wearing a wig and pigtails and a 5 o'clock shadow and showed that as the picture on the ad, you know, you could obviously tell it's a 45-year-old bald-headed guy wearing a wig and pigtails. But you know, how many people are you going to pick up? None. So they don't do that. Instead, they decide to break the law because they can catch more fish, so to speak. This is the actual law, and your state law is probably a copy of this. Anyone who intercepts or endeavors to intercept or procures another person to intercept or endeavor to intercept any electronic or oral communication commits a federal crime and a felony. If you disclose this, item C is disclosing it for any reason to any person for any purpose, like in court to prosecute somebody, it is another felony and a federal crime. If you use it to prosecute someone or shame them in the newspaper, it's another felony and a federal crime. If you use a recording device like a tape recorder or a special equipment on a phone to record a phone call, that's item number B. That's another felony and a federal crime if you're impersonating somebody else. Next one. Content. What is content? I have to, you have to know all the meanings of these terms in order to understand law. Content includes any information concerning the substance or meaning of the communication. So an audio recording of a phone call, notes about the phone call, a testimony about the phone call, text messages, subject line, hash codes, anything that talks about the content of what was said or typed is content. Okay, next. Intercept. What does intercept? It doesn't necessarily mean tap a wire to your landline and put the headset on from the 1960s. They realized that was too tight of a definition. So they broadened it because you can't wiretap a wireless phone. You can't wiretap a fiber optic line to your computer that's on Wi-Fi. Okay, so intercept is much broader. It simply means to acquire the content. That's it. And it doesn't, you don't have to need a separate device. My example here is the USV Sizes Kamiski. I cannot pronounce the name. I've been trying for years. I cannot pronounce his name. He was a system administrator and he set up auto forwarding on his boss's emails. So a copy of all the emails would be sent to him so he could see what his boss was up to. He got prosecuted and convicted of illegal interception of communications just by setting up auto forwarding. So you don't need a separate device with a headset. Anything will do. If you acquire the content other than what is legal in the law, you have intercept. Endeavoring to intercept. This is important because if they post an ad showing a picture of a female and it's a 45-year-old guy impersonating her, and they give the officer's phone number or email, they are endeavoring to intercept using impersonation. So the first criminal act in most of these cases is by the officer. And that makes a big difference sometimes for how the case goes. All right, next. Exceptions. Essentially, anytime you intercept it is a crime, including intercepting your own stuff. So they had to make an exceptions for the law. So it is legal to intercept or acquire your own communications where such person is a party to the communication. And that same caveat is given and required for law enforcement. So the C is for people who are in federal law enforcement, not necessarily states. You have to check the state to see what your state's copy is. Virginia gives no exception for police. There is nothing written in there for police at all. You must be party to a communication and there's no exception for police. All right, now, have you seen anything about written permission here? This is the law. There's nothing in written permission. Now, recorded phone calls. In the Alex VA case, he procured officer number 3 to be a voice of Alex VA on recorded phone calls. So he used a phone. My phone can't record a phone call. I mean, it has a recording capability if I talk, but it can't record both sides of a phone call. So he has a special recording capability installed that he wanted this other officer to use. So he procured the other officer to not only impersonate, but to record the conversation while impersonating. And they used the detective's phone because he had used this for texting and he wanted the numbers to match. So he used it as an identification. And using an electronic device or procuring someone else to use it for you is a violation. Recording live videos also has sound. That also qualifies as recording voice. That's why all your security cameras in the banks and that do not have audio recording, because otherwise they'd be interception devices and everybody was to be charged with this crime. So that's why they're picture only. But if they record any sound, they have intercepted sound. Okay, next. Identifying yourself with someone else's photo. This is training that they give. They teach the officers to break the law. They say, other than images of an individual or older who provided their written consent at their time they were employed by law enforcement, you can't use anything else, okay? I just read the law to you. Where did you see written consent? There's no exception for written consent. Written consent is a worthless piece of paper because there's nothing that makes it legal to impersonate someone else and intercept communications if you get written consent, even if you're an officer. Violating interception law. Written permission is a worthless piece of paper because there's nothing to make it legal. You also have Ashcroft versus free speech, which is a good case law to cite. Statutes can only be applied to images of real children, not computer generated images. This is a Supreme Court ruling. You really have to cite this a lot. Image that is or appears to be a minor were ruled overbroad and may not indicate the exploitation of real children. Well, if you've got a 45-year-old guy posting a picture of an adult woman, that's not a child. But no one's been able to, I've tried to put this in my briefs, but I will put it up there for good reference and hopefully somebody will actually win on it someday. So let's continue. Also, identity theft. State identity theft is a lot more stringent because you have to use someone else's identity to get money. But federal identity theft is broader. If you use someone else's identity to commit a crime, a federal crime or a felony under state law, you have committed identity theft. So means of identification include photos. So using someone else's photo to commit a crime, like illegally intercept their communications, is identity theft, or using someone else's phone number. So if you take over the phone number of a teenager and use their phone as identification, so when you text them, they think it's coming from the teen, that is identity theft. Here, do these look alike? All right, on the left is Lily, another picture of Lily, and it's dated to, one of these pictures is dated 2008. That's a photo taken 10 years later of Yesley Vega. Now, the person in the picture did nothing illegal. She was doing her patriotic duty. If she says it's not her, I'll leave that to her. But what happened is that the case was from an officer in the Richmond area, up here close to my neck of the woods. And Yesley Vega lives about 100 miles from Richmond, where she started her career. So she started in, down there, then she got married, and came back, and then they settled. So for 10 years, the Richmond officers have been pimping this woman, this female, Lily, all across, who knows where, across the state, across the country. And she was recognized in the arrest because Yesley Vega's fellow officers recognized Lily in the photo as the girl in the office. It's on the arrest tapes. So no woman signs up to be pimped for 10 years and impersonated as being a good time call girl when now you're a wife and mother and you don't even work for them and haven't for 10 years. Users agreements. User agreements are the most boring piece of information anybody ever wants to read, except when you realize it can save your life. And the Grindr user agreement is one of the best ones I've read. Irrespective of what you think of Grindr, it has an awesome user agreement. It says you must be an adult. You confirm you're 18. You can't use images of children. You can't impersonate, and it's for individuals' use only, not for use by the government. And you can't represent the source. So if you violate the user agreement, this is a big deal that can be woven into a case. If in federal cases, it violates the DFAR and the FAR federal regulations for acquiring and using commercial products. And if you violate the user agreement and violate the DFAR and the FAR, it's a Giglio violation, which is similar to Rady violation. You can throw it out just for violating policies and procedures. What is a user? A user is anyone duly authorized by the provider. So if you violate the user agreement, you're an illegal user in the criminal code. And the phone or the computer is then being used as an interception device. Okay, next. What is an interception device? It's electronic or other device to be used to intercept electronic wire communications other than telephones or equipment or components used in the ordinary course of business or in the ordinary course of an officer's duty. Well, if an officer is illegal impersonating somebody else and violating the user agreements, that's not ordinary course of business. So they don't get to qualify for this exception. So they are using it as an interception device. Intercepting across state lines. Where were you? Where was the officer? Here we have a Virginia officer. They asked, and the prosecutor said, "Oh, where were you when you?" "Oh, I was up in Maryland." "Excuse me?" And my ears perked up. It's like, wait a minute. And it takes me a while to mull this over in my head. But the officer traveled to Maryland. We had no legal authority. He was intercepting across state lines. And Maryland is a two-party consent state, so both the sender and the receiver must consent. Do you remember Monica Lewinsky and Linda Tripp? Do those names ring a bell? Because Linda Tripp was in Virginia when she recorded a phone call with Monica Lewinsky. And Linda Tripp got brought up on interception charges because she intercepted across state lines, and Maryland is a two-party consent state. So what did we do? Mr. Asian and I called the Maryland police departments all over the place. "Hey, we want to report interception across state lines like Linda Tripp and Monica Lewinsky." "Oh, we don't prosecute police." Talk about a double standard. All right, next. Other criteria that must be met. You have to show that you had an assumption of privacy. You can't be on a speakerphone in a busy restaurant. There's no probable cause to begin it. I mean, all these conversations, they start recording at the word hello with an anonymous person on a dating site. What crime could you possibly think could be the basis of probable cause for a stranger saying hello on an adult-only dating site? There is none. And they never get a warrant for any of this. This is all done without a warrant or authorization to intercept. So it's all criminal. Next. So you can only get an authorization to intercept for crimes like kidnapping, murder, extortion, and bribery. In Virginia, you can't get it for possession of child pornography, and you can't get it for soliciting a minor. So there's no way you can get it. There's a few little caveats in the federal codes, so check your state as far as whether or not they could even get one for possession of child pornography. In Virginia, only state police can do it, and they have all the local law enforcement doing it, and you can only do it for 30 days, but they have hunted people for 3 years until they could trip them up and get them arrested. 3 years bugging somebody. Next. Other alternatives. They have to identify themselves correctly. They can wear a disguise like a wig and pigtails, 45-year-old bald-headed guy with a wig and pigtails. That would be legal from the interception perspective, but they're not going to catch anybody. I don't know of any way you could impersonate somebody else or use an imaginary person, because that imaginary person is a thing. You can't use things. All right. I'm going to take a sip of water and let you write down a question here, and then we'll just keep on going. Okay. Next. Unmasking identities. This happens in both child pornography and solicitation of minor. Improper methods are being used to identify suspects. First of all, they get chat content that's illegally intercepted, and people give away personally identifying information like, "Oh, my Snapchat account is this, my email is this, my name is this, I work here." They also get the hidden IP addresses without a pen register warrant, and they use administrative subpoenas and not warrants to unmask their identities. Pen register law is, they said, well, you got to look at the pen register law. It's like, what's a pen register? So I looked at it. It's not just a device that you hook up to a phone to see who somebody's dialing. It also is a process that records and decodes dialing, routing, or addressing information. An IP address is an address. Dialing is a phone number. Routing is your cell tower and all that other stuff. Where do the messages go? And traps and traces, where do they come from? So any process that records or decodes this needs a warrant. Next, they use Dropbox. I couldn't understand why they're sending all these pictures using a Dropbox link instead of just sending the photo. So I asked Dropbox, hey, you know, Mr. Help or Miss Help at Dropbox, can you get the IP address of someone who's taking something out of your Dropbox? Oh yeah, you push these buttons, and sure enough, you can get the IP address of someone if they take a picture of a flower out of your out of the cop's mailbox and look at a picture of the flower. They get your IP address and they can identify you. That's why they use Dropbox. There's other ways to do it too, but this is another one of them that I have shown, because the officer identified the suspect 10 days before he got the reply back from the administrative subpoenas. Like, how did he do that? So I figured it out. All right. Next, account ownership. A government entity may be required to disclose information only when the government agency provides a warrant or a court order. There's a few other caveats in there. You got to read it, but it does require a warrant. And next, the court has ruled in here, and the top one, I misquoted the Smith v. Maryland, but they do require, in the Trump administration, there's all this fuss about, well, they unmask the identity of people without getting a FISA warrant. Well, FISA is if someone's on a phone to somebody in the foreign country. Here, a pen register is if you're on the phone to somebody in this country. So you shouldn't have if they're both US, you shouldn't have just an administrative subpoena if you need a warrant to get it if they're talking to a foreigner. So, but you need a warrant to do an email, a warrant to do geolocation, and a few other, if the warrants for geofences are too broad, those also are not acceptable. All right, next. You also have a right to remain anonymous, and here's some case law for that. Next. Again, I'm going to take a sip of water, and then we're going to get into the child pornography stuff, which is a little more challenging. Okay. Child pornography on peer-to-peer networks. The best way to do this, I'm going to read this. I apologize, but you probably can't read the fine print from wherever you're sitting. So the best way to describe it is just for me to read this to you. Okay. This is sworn testimony. While using an undercover operation using law enforcement tools, I saw an IP address. How about that? That had been notified by our tools to have known or suspected pornography. I then downloaded it. Again, I'm underlying some stuff here because I'm going to talk about it later. With a tool called Shiraza LE, only for law enforcement, and I was able to get the files. Once I downloaded it, I utilized the system to obtain records to identify the subscriber to the IP address. I then contacted the local jurisdiction and coordinated from there. All right, next. More questioning. Other than the automated computer database, you described what brought your attention to that IP address. The database we use. And how did you know the files were there? With the file names attached to them, and we had similar files in our core system. Okay, next. And so prior to getting the search warrant, you had a partial download from this IP address. Yes, ma'am. Did you download it before or after you executed the search warrant? It was before. And my jaw dropped on the floor because no one in that court, I was reading this transcript, I wasn't there. No one in the courtroom said boo. They remotely searched someone's computer, took files off of it, and did not have a warrant at all. And no one said boo. Next. All right, so this brings up questions. Where did that IP address come from? Why was this IP address selected instead of Bonnie's? How did the officer access a password protected computer and get in? How did he download files? What system did he use to identify the suspect? And how did he figure out where this person was and what was local? Next, and mostly, where are the warrants? Because there are not any. Unintended confessions by the officer. This is not throughout the whole testimony. ICAC has a database inventorying content downloaded to people's private computers. Let that sink in a minute. Access, I'm going to translate these words for everybody. Access means to break in. Download means to steal a copy. The core system includes a library of child pornography with hash codes, and I can't fuss too much about that. If they want to download pornography, and then that's their business. But the core system also means they submit administrative subpoenas instead of getting warrants. And I think there's a few other things going on too, but I can't necessarily put my finger on it with the testimony I've seen. Local jurisdiction means that he geolocated the suspect without a warrant. And law enforcement only means it's not publicly available. And these are all in the law and in federal documents, policies, and procedures. Okay, next. ICAP claims they don't need a warrant because it's publicly available. So I'm going to play devil's advocate here. I'm a system administrator on top secret government computers. Okay, I can't do this. I have the knowledge to do it, but I feel it is a crime to do it. I write software, I build interception systems for a living, and I have for like 30 years and counting. I don't want to count how much exactly, but I've been doing it for a lot of years. So this means I can do this too, based on their testimony, or anyone else. Any reason is okay, not just child pornography. You don't have a warrant with probable cause. You can do it for pro-life, pro-abortion, Democrat, Republican, whatever you want. And I can, if they can use and disclose it, I can too, and I can sell it for profit on a website and make my own database. Next. Director of National Intelligence says information must be available to the new member of the general public, not just the file, the information contained in the file. So you have to, if you have to have the means to get the information out. Now, how do they get into the peer-to-peer? What is a peer-to-peer? It's a shared, they call it shared, but it's actually a file transfer system used to transfer large files in videos. It's free, it's layered on the BitTorrent protocol. And what happens is that the file is too big. And if Windows uses this to deliver. So you don't want to plug the internet wires with a copy of Windows coming from Seattle, Washington, every single time somebody in Springfield, Virginia wants a copy. So what they do is they copy one copy to me, and then if somebody else in town wants it, they just manage the copy from my computer to their computer, and then it doesn't take up as much wire time. So that's why it was invented, but it's not just for surreptitious use, it's actually for real deliveries of large files. And let me explain it. Here's a puppy dog. I want a picture of a puppy dog, but it's too big, so it has to be chopped up into pieces. These are also called partial files if you read anybody's officer's testimony. So it's chopped up in 3 pieces and reassembled when it arrives. Each piece is validated with a hash code. And they take each byte, crunch it through a formula, it pops a number. Once it's shipped, they crunch it through the same formula. If the bytes match, great. If not, you had a transmission problem. You have to retransmit. That is the only reason you have a hash code. If you use it for any other purpose, you're violating the law and violating the internals of the transmission system. For example, you have the head, the front paws, and the tail. And I invented some hash codes here, 1, 2, 3, 4, 5. So if you see a hash code, 1, 2, 3, 4, 5, you instantly know I downloaded the head piece of the doggy file. So that's how they take a hash code, and they know the pieces because they got the hash codes in their library. Now there's bookkeeping files that are to keep track of all this stuff. First is the torrent file, and it is like a table of contents. It lists the file names, it lists how many pieces there are. There's 3 pieces and the hash code for each piece. And it also has an address for the tracker file, which is someplace on the World Wide Web. And next, the tracker file is the keeps track of where all the pieces have gone. So many people have downloaded the head. Somebody had an interrupt, so they didn't get the tail, but they got the head. So it keeps track of the IP address for every single piece that's been downloaded. There's other information called like date and time of download and subscriber information, which aren't necessarily in the BitTorrent documentation, but they are stored probably in the product that like Emil, Donkey, Schrazer, whoever, they are keeping track of that. All right, next. Problem. They use the hash codes to fingerprint, and that is law enforcement term, the content downloaded. And this is a violation of the Stored Communication Act because they're exceeding the authority to use the system. This is the wiretapping software that I'm going to talk about of how they break in and steal this stuff. Torrential downpour or something similar. It breaks into the bookkeeping files that I talked about, and it steals the transactional records of who downloaded what, where, when. It loads this into the database. It's run periodically, and any new IP addresses for files that are considered of interest generates an alert, and the officer is then informed that this IP address is downloaded something you are interested in. Some of these might even be located on a French server to possibly circumvent US law. The AdCat COPS database contains file names, IP addresses, date and time, subscriber information, and hash codes. I just talked about where all those were in the bookkeeping files. So being an engineer, I said, well, they don't just float out of the sky and land on the COPS lap. They have to come from someplace. So I went and I delved into the design and figured out where they came from. And that's where they came from. And now they're in the database. All right, next. Freenet is another one. I just did a case on Freenet. It's a modified version. They actually actively tap into the network and without a warrant. All this is done without a warrant. Filling the database is all done with the warrant. Generating alerts without a warrant. All this is done illegally without a warrant. They monitor network traffic carried over an internet wire, and it extracts the same type of stuff, IP addresses, number of peers, and they have this fancy formula to figure out what you downloaded. So anything that gives a purported meaning of what was downloaded is content. So that fancy formula is content. You can't intercept content unless you have a warrant. Monitoring is illegal. So this Freenet tool that they have, the Freenet customized software, is law enforcement only, and it monitors network traffic. You can't monitor, not even phone companies can monitor. And when I helped the attorney write this, it happened, we had to write oral arguments, and I gave the Mother's Day example because I actually had to write it on Mother's Day. I said the telephone company cannot monitor phone calls for who sent Mother's Day greetings, and they can't monitor who called whom and figure out children and mothers based on who called whom. That is monitoring. Telephone companies can't do that. It is a private communication service provided to the public. That's what peer-to-peer is too. You can't monitor private file transfers either. Content, again, anything that gives purported meaning, includes hash codes and that silly probabilistic formula that they are so full of themselves about. Oh, it's 98% accurate. Oh, I'm sorry. I did statistics. Just gagged me. There's no authorization to intercept content. Any person who intercepts any content, electronic or oral communication, discloses it or uses it, commits 3 felonies here listed and 3 federal crimes. Okay, stored communication law. Anyone who exceeds the authorization to access a facility and obtains communications while they're in storage shall be punished. Okay, what are they doing with this wiretapping software? They are exceeding the authorization to access this facility because they're breaking in and stealing transactional records and running and monitoring communications while they're in storage. And they're stealing the hash codes while they're in storage. What's a facility? It's a dictionary definition, something that's built, installed, and serves a purpose. Well, software is built by people like me, installed on a computer, and serves a purpose. Okay, it's a facility. It's protected. Next. Violations. They break in and steal transactional records, and then they break into people's computers and steal their content that's all they have on their computers. This is what I'm going to get into next. Violates the user agreement. Freenet has in their contract that users have no control over what's put on their computer. You share a piece of your disk space and you have no control over what Freenet puts on there. Be aware of that. So how do you have intent when you didn't put it on there and you didn't request it. Read the user agreement. These will save your life. Boring as all get out, but they are very exciting when you realize what they really can do for you. Shiraza LE. This is a tool that breaks into computers and steals your content. Shiraza LE means law enforcement. It's like doesn't go into the front door with the username and password. It goes in the back door through a port. You know how, overnight your computer got an update from Windows. We updated your software. Aren't you happy? Don't you want to see the new features? That is, you didn't log into Microsoft and say, do that. You have an agreement with Microsoft and you have a contract with them to say you can update my software when I'm sleeping, so I don't have to deal with you taking over my computer for an hour when I'm, got to start work. That's what they're doing, is they are creating a hacking program that mimics a server of Emule, eDonkey, or whatever, and because they're paying it. They're paying Shiraza. Shiraza LME means they paid Shiraza to build an LE version. So they paid them to make a specialized version, allow them to break in and steal your stuff. And it is a two-way portal. So not only can they take files off your computer, they can plant evidence. Let me repeat that. It is a two-way portal. They have the capability to plant evidence. Next. Location of the evidence determines if a warrant is required. This is DOJ's own documentation. You are using a computer that is password protected in your private home, and they don't have a warrant for it when they do this. You need a warrant because of the location of the evidence. Kylo, also, the computer searching the interior of a home from the outside requires a warrant. Well, they're searching the interior of your computer that's inside the interior home. Why we don't, but the attorneys are not tech savvy enough, and they don't realize that these laws actually apply to solicitation and child pornography cases. We got to educate them, please. User agreements. I talked about this a little bit. They're under contract. The government is paying Shiraza to build interception. They are procuring someone else to intercept communications for them. Does that sound like a violation of the law that I've been talking about? Computer trespass. Breaking into your computer and stealing stuff is a state level computer trespass. They modified the federal code because I think they're getting bogged down with too many trespass. So they said, oh, we're only going to protect government federal computers and leave the state to protect the rest. So check your state laws for computer trespass. This is a felony in Virginia. Other problems. If you make a mistake, you can never correct it because that tracker file is not on your computer. Even if you erase your computer, it keeps track of it. It's somewhere on the World Wide Web and you have no idea where it is and you cannot correct it even if you did know. Table of contents is not controlled. So it's easy to download a piece of innocent material and have child pornography tagged at the end of it. These are all nice even pieces, like a 1/4 megabyte. Snip, snip, snip. You can easily, person with one programming class can write a snip, snip, snip program to replace whatever they want or tack it at the end. You will never know. But the hash code is calculated based on these wonderful, nice, even pieces, and you will be flagged for having child pornography. No traceability. I've built interception systems. I've been a targeter. I know what we do to foreigners, okay? And here you have local police. They have no control of the computers. They go wandering off to vacation in Maryland and take them with them. There's no logging of what they do, no documentation of how many people they talk to, no tracking of what tool is used, when it was, where's the warrant before you start, nothing. And this log should be produced at every single trial because terrorists get this, okay? Why don't US citizens get it? I'm getting a little spun up. I got to calm down. Next. Here is the control panel for their wiretapping software. All right, you can't read this very well, but it has a pie chart. You can see that little pie floating there, giving you a pie chart of what has been categorized by hash code and what hasn't. It has on the side under there, it says subpoena sent. It doesn't say warrant, it says subpoena. So they have some automatic capacity to either track it or send it automatically. Now you push the button on what you want to wiretap today. There's eMule, eDonkey, BitTorrent, just push the button. It tells you we've got 647 things you might have interest. And the lower sections that are, this is from a FISA request down in Florida. It has the account names, date of the IP addresses. Some of the IP addresses are masked, but it says data lookup IP address. So it's got all the IP addresses right there. You just push the button, wiretap away. From what I've seen, terrorists have more protection than US citizens. That is a sad statement, if I ever said one. I updated these slides a bit from the book. There's approximately 160,000 people nationwide who've been manufactured into criminals or had their rights criminally violated by officers. 160,000 people should not be on the registry. There's a whole bunch of officers that should be. They have, this is money. I didn't update the money on this yet. So it's a little bit old with the money. There's more money now. $500,000 in federal grants, about the same in state and local grants. But that pales in comparison to the $130 a day, like Virginia pays the local governments to incarcerate someone. So one of the counties here, Stafford County, was using this as a way to fund their brand new sheriff building, $26 million, but they would pack 120 people into an 80-person facility with only 80 beds and put a bed on the floor. So they had to take turns for who got to stand up, and they would cram them in for year after year after year. And they got $5.6 million a year doing this to pay for the $20 million new sheriff building. They didn't expand the jail, but they got their money. Billion-dollar industry. Next. This is a summary of all the laws being violated. Interception laws, pen registry laws, identity theft. For child pornography, you've got interception law, stored communication law, computer trespass. Best defense is a good offense. The crime of misprison is if you know a crime has been committed and you don't report it, you are now committing a crime. And you can report this to a judge, because I have tried to report it to the police and they blow me off. Attorney generals blow me off, but you can report it to a judge. So I would suggest writing up this stuff and report it. Next. Report it to a grand jury. Citizens have a right, and I am currently suing the entire county of Fairfax County and the chief judges, and it's now on appeal, and I have oral arguments on the 26th to go in there, and I'm going to present evidence and give them my own indictments. Okay, next. You can do this depending on the state. California, all I have to do is send grand jury an email. Bye. Next. Questions. Now that's kind of my presentation, so I'll open this up for questions. So, and I think I got enough time for questions. And
I don't know. We're waiting. You want me to go on?
You know what?
You were a question.
Yeah.
So Bonnie, I have a question.
sure.
To what extent does the emerging AI like GPT and the ability to manufacture sort of artificial things affect this whole landscape?
Well, when you have geomorphs, those are things. And anytime you have an AI robot, I mean, think of how many solicitation cases they could manufacture and run if they used AI. I mean, there's also technology to create a video that moves. I could, you use points on a screen, and I'm moving my hands here, but I could put your image and your body structure, especially Dustin. I could put Dustin on top of me. We don't look a lot alike at all, but I can make him move just like I am. And that technology exists. So it's very scary to have true imaginary people. And especially if someone's a public figure, they have lots of video that they can draw from. A little bit of news too. In New York, the case I'm working on New York on Freenet, it's been 2.5 months now, and we stumped the judge. So it's a motion to suppress, and he still has not given a ruling on a motion to suppress after oral arguments finished from the Mother's Day argument. So hopefully, fingers crossed, that's the first time I've ever worked on a CP case. Hopefully it's a landmark. It's called it'll be the Looney decision. What a name. That's the guy's last name, Looney. It'll be a Looney decision.
That's awesome. So we have some questions from our group here. One of them is about how probation officers monitor people on lifetime probation here in Arizona. They install tracking software on your computer like NetNanny, and they also intercept or read your text messages. How does that play into kind of what your talk was about?
All right, what I have heard from attorneys is once you're convicted, you lose your Fourth Amendment rights.
There it is.
Okay, that's from an attorney.
That's fair.
Right.
So if someone's allowed to remain anonymous, how does law enforcement get the IP?
They break the law.
Okay,
Because you need a pen register law to get the addressing, because pen registers protect the addressing and routing, and any process to get the addressing and routing requires a pen register warrant. What they're doing is, I think there's a bit of a conflict in the law. You have to look at 18 US Code 2703 C, I believe it is. You can do administrative subpoenas, but it's kind of worded badly, and it says if you have the subscriber, you can get his stuff. But what they're doing is they're twisting it, and they're like, okay, give me all the information, and they're just doing administrative subpoenas, but they're not saying, okay, I have the subscriber and I want his email and his contacts and stuff. They're saying, I got a message, now give me all the information about it. And it doesn't quite work that way for that law. So you need a pen register law to actually take like nothing and go to an IP address. If so.
right. One of the big problems in the criminal justice system is that itself has no accountability because it would have to hold itself accountable. And that is something that we just don't see very much of, cops arresting themselves and the like. But you're saying that the police are breaking these federal laws in multiple different ways. And the question that we have is, how can this be addressed? But from what I heard you said, we can go directly to a judge with this.
Yes, look at the crime of misprison. You can report it to a judge. That is a federal law, so it might have to be a federal judge. So you'll have to cite the federal statutes. But as far as I know, you can go to that. That's what the law says. You can go to a judge. You can also go to a grand jury. And it's interesting you talk about police want to arrest police. That's exactly my point with trying to go to the grand jury, because I've tried the police, the sheriff, the attorney general, state police. And they flat out told me, the attorney general told me, it's not our job to enforce the law. Really? What's an attorney general for? Some states don't have an attorney general. Police laughed me out of the room. So I am wanting to go to the grand jury, and now the judge is stepping in and saying, we're taking authority that we don't have, and we're preventing you from going. So that's my argument.
Wow. So for anybody who has already signed a plea under charges like this, are they burnt? Or if you can go back ex post facto and prove that they didn't get the evidence in the first place legally, but they still leveraged it to get you to sign a plea.
All right. I have some good news on that part, and it comes from my grand jury efforts. There is a case, it's US v. Williams, that has to do with grand jury. And that is, they said that a judge has no authority over a grand jury. They can make an indictment even on hearsay. They can make an indictment on whatever they want. There's no procedures for what they can do in an indictment. However, once the indictment comes out of the grand jury and it's signed, the judge can look at it, and if the judge determines there is misconduct that occurred in front of the grand jury, the judge can dismiss the indictment. Well, if the officers committed felonies and federal crimes in front of the grand jurors by using and disclosing illegally obtained information, I believe that rises to the level of misconduct, and you can dismiss it. So that's what we're going with anyway. And that was an idea from a 90-year-old attorney friend of mine who's giving you some advice.
That was literally the question I just asked you. That's hilarious. Does anybody else have?
Yeah, I have
any-
one question.
Jump in, I'll grab this.
To what extent do VPNs affect their ability to do some of the intercept and tracking?
VPNs, well, for every VPN, it's like a hop, step and a skip, you pretend you're in Florida, but you're really here. You pretend you're in France, but you're really here. And sometimes you can go hopping a lot. They can, well, it depends on the sophistication. I mean, they have the technology to unhop everything. It just depends on, I think the local police department has got like onesie twosies, probably doesn't have that capability, but they can undo all the VPNs. If they really want to.
Well, a lot of the VPNs don't keep logs. So what is it that they look for?
They have their ways. I don't know exactly what they are, but they have their ways.
So what about the current effort by the FBI and the MCMEC to get the law to break end-to-end encryption? And in quotes, it says, "We promise to only fish for bad stuff."
They need a warrant first. I don't have a problem with them breaking, because if you look at the pen register, it says, has the word decoding, anything to decode. And that decoding applies two ways. One is to decode the envelope and one is to decode the content. So decoding, encoding, decoding, encrypting, decrypting, anything that allows you the ability to interpret the bytes and extract information from those bytes. Because I do software. I mean, I use my source code and I say, oh, today I want to make these bytes be a picture. So I just take literally my characters, my bytes, and I just say, today I'm going to show it painted on a screen, and tomorrow I'm going to pretend they're integers, and tomorrow next day I'm going to pretend they're floats, just to invent some dummy data. So, if you have to be able to interpret those bytes, and if you don't have a publicly available tool like Microsoft Word or spreadsheet or something, that tool allows you to decode the information, decryption, whatever. That's part of the decode. And then when you apply the word decode to addressing, that is getting the ownership and decoding the IP address for who that belongs to. So to me, I believe there's two applications of the word decode, is the ability to get the real meaning behind the addressing and also behind the content.
How hard is it to actually get a hold of somebody's IP address? Like if I wanted to find out my neighbor's IP address.
You can do what the police do, send them a Dropbox and have them take a picture of a pretty flower out of it. I have instructions in my book on how to do that. But as far as literally that is a sneaky, almost illegal way to do it, but you can't get an IP address for your neighbor, and the companies that provide services intentionally generalize the IP addresses to a 25-mile radius in a highly densely populated area. And some places in low population areas, they will generalize it to a 75-mile radius to intentionally mask, because they cannot, it is required that they keep your identity. So at least like they cannot uniquely identify you to within 1,000 people. So there's requirements that they cannot do anything that will allow anyone to identify an IP address to a person. And that is a requirement for the service providers. And there's analysis in my book for how good some of these are. Some of them don't even get the right state. They have 98% chance of getting the correct state.
That is a great answer to that question. Does anybody have anything else? We are running up to the end of our time. So anything else in conclusion? Well, we really appreciate you spending your time with us. This has been a wealth of knowledge and incredibly insightful. I learned a ton, and I think everybody else did. Everybody's eyes were glued to the screen the entire time. They're
Well-
standing, you're getting a standing ovation right now.
Thank you. Thank
We
you.
appreciate you. All right, well, thank you again for your time. You have a great evening.
All right. Thank you
Good
for
luck on the
having me.
quiz.
This
We'll
has been
follow.
very nice.
Thank you.
All right.
Great.
Take care.
Thank you. Good night.
Good night.